So welcome everyone. As you know, the monthly Learn Over Lunch, but we're foregoing lunch during our virtual meetings right now, is brought to you by the Education Committee of the Santa Barbara Association of Realtors. My name is Deborah Schwartz, and I am an affiliate member of the association and a member of the committee. Today, we have a very exciting set of co-panelists, and I'll be introducing them shortly. But first, we have a couple of housekeeping items. We have a raffle. I don't hear a drum roll, but that's because I asked you to mute. We have a raffle, and you must be present to win. So please stay with us if you're interested in participating in the raffle today. The raffle is sponsored by Weiser Insurance. We have Kelly Weiser here. You'll see her on the screen with Weiser Insurance. And so, Kelly, I'd like to turn it over to you for a few minutes to tell us more about your agency. And Kelly, again, is also a member of the Education Committee and an affiliate member of the association.
Wonderful. Well, thank you so much, Deborah. I'm so excited for the chance to be here today. As you said, I'm Kelly Weiser with the Weiser Agency. We're a local insurance agency here in town with offices on the Riviera and in Ventura as well. Today, I want to share just a little bit about how we can help you all, some insurance market tips and what's happening at the moment so that you can best advise your clients. And then, of course, talk a little bit about the raffle, which is probably what you're most excited about. But insurance is exciting too, I promise. So a little bit about us. First, thanks to so many great partners like many of you, we're consistently ranked within the top 1% of farmers agencies in the country. We're the only local firm with that designation, so we're really grateful for that. We love getting to help with everything from a straightforward condo downtown to a more complex or high-end Montecito estate that's deemed to be in a high-risk fire area. As I'm sure you're seeing a lot of these days, we're seeing a lot of it as well. So happy to help big and small however we can. Specifically, I'm confident that we can help y'all in three key ways. One is advising on the insurability of a property. We get a lot of questions about that, and we're always happy to help as a thought partner. Two is providing a ballpark estimate for any of your clients that are looking to make an offer on a property to get a sense of what insurance might be, as well as for you all if you're going out on any listing appointments and want to know before you walk into that appointment what the insurance options would be in that area. So happy to help with those two ways. And then, of course, we're happy to offer insurance directly and serve really as that counsel and that thoughtful advisor for your clients when it comes to all their questions for anything insurance related. So we can help with the smooth close, and you can focus then on all the other aspects of getting your clients into their homes. So in terms of what's happening in the insurance market these days, we're often asked by clients why insurance is so hard to find here, even though it's been multiple years since our Thomas fire and debris flow. We're really grateful that we have had a very peaceful, I'd say, fire season this last season here in our community, so super grateful for that. But the reason why insurance can still be a challenge to find these days is because insurance companies really look at the risk of insuring throughout both here locally, but throughout the state as well.
Kelly, hold on one moment. We're getting some background interference. Oh, I think we've resolved it. I see Casey working on something. So go ahead, Kelly. Thanks.
Yeah, of course. Thank you, Casey, for fixing that. So in 2020, in addition to being so many other things, for many of us, it was actually the worst year for wildfires in California ever. So to put it into context, with our Thomas fire here, we lost 1,000 structures, homes, businesses, all those types of things. And in 2020, in literally just a 12-week period, we lost 6,000 structures throughout the state. So our Thomas fire is no longer one of the top 5 worst in the state. We're down to number 7 just because of activity really in the last 6 months. So that's a big reason why it can still be so difficult to find insurance options here locally, even though we've been lucky enough not to have any sort of big big fires here, and we hope to continue that. So the good news is, and to share with your clients, is that we do continue to see new insurance companies enter our market here. We've had 3 new options enter just in the past 60 days. So we're continuing to see options that we're really excited about there. Um, yeah, and that's a little about us, a little bit about the insurance market. Hopefully that's helpful for you as you're speaking with your clients. And with that, I'll share that our raffle prize for later today is really focused on a self-care package that our lucky winner will get to enjoy. So it features little gifts from lots of different Santa Barbara companies, such as Springtide Nails, and then a few others that are small, locally owned. So,
Tab 19.
with that, I'll hand it back to Deborah.
Thank you again, Kelly, and to Wiser Insurance. It's great to have you on the committee and being a host today. Just as we have more folks coming online, if you would please go ahead and mute yourself, and very excited to see so many participants here today from the association. Now, before I introduce the program and our panelists, wanted to make a quick announcement about the association's real estate market update. It is scheduled for tomorrow. That's the 17th at 3 p.m. on Zoom. It's a complimentary event, so if you're interested and you haven't already registered, we encourage you to do that. With that, now we're gonna come to our program today. Hopefully all of you have seen the flyer entitled Trusted Professionals in Trust, Prop 19 and Estate Planning. And throughout the program, if you have questions, I'm going to monitor the chat function. So feel free to include your questions. We're really looking forward to hearing from you and giving our panelists an opportunity towards the end of the program to answer those questions. So let's get right to introductions. It's very exciting today to have Lori Lewis, a partner at the firm Mullen and Hensel. She's up here on the screen already. And Lori is a partner at the firm. She is certified by the Board of Legal Specialization of the State Bar of California as a probate, estate planning, and trust law specialist. Her practice is concentrated in the areas of estate planning, advising clients on powers of attorney, conservatorships, advanced healthcare directives, wills, and trusts. Lori handles legal matters that often involve the high emotional intensity of family conflict. For that reason, when necessary and appropriate, she uses tools of mediation or litigation or both to resolve conflicts related to conservatorship and post-death probate and trust administrations. She works closely with individuals and their professionals, such as income tax preparers, medical caregivers, and investment advisors in giving advice and preparing customized incapacity and estate planning documents. Lori also works with private and professional fiduciaries and family members in administering conservatorship, probate, or trust administrations. Lori is active in the Santa Barbara nonprofit community, serving on the Hospice of Santa Barbara Board, as a member of the senior advisory panel of the Legal Aid Foundation of Santa Barbara, and is also a member of the Planned Giving Committee for the Fund for Santa Barbara. Welcome, Lori, and thank you so much for taking the time to be with us today and sharing your expertise. Now we go to David Graff. David is a partner at Allen and Kimball LLP in Santa Barbara. He is a State Bar of California certified specialist in both estate planning, trust and probate law, as well as taxation law. He advises individual clients and families planning the transfer of their wealth from one generation to the next to provide for friends and loved ones or to accomplish philanthropic goals. His representation provides not just for the creation of an estate plan, but an overall strategy for each client, including estate, gift, income, and property tax analysis, consideration of insurance and retirement plans, business planning, and coordination with other professionals. He serves on the boards of directors of several local charities and is active in many Santa Barbara civic organizations. Along with his wife, daughter, and dog, David enjoys traveling, hiking, camping, and scuba diving. He received his BA at the University of Pennsylvania, his JD from the University of California at Davis, and a master's degree in tax law from New York University. He's a member of the State Bar of California and is licensed to practice in the United States Tax Court. Again, welcome to both of you. We've talked about how we're going to coordinate the various topics. So Lori, could we start off with you to talk about the benefits of estate planning and trust and sort of companion topics that come along with that?
Yes, of course. Happy to give us a jump start here. First, on behalf of both David and I, we want to thank you for making time on your lunch hour to talk about the topics of title, death, and incapacity. These usually are not, great, great draws in topics, but we recognize that the professional group that you have organized brings with you a lot of your own personal and professional education involving how important title is to real property for insurability, and also how the form of title that your clients takes affects what happens when one of the owners becomes incapacitated or dies. Many of you have handled property purchases where families are selling properties as a result of death or incapacity, and you understand how an estate plan affects the life of an escrow and all the various choices that are available for your clients out there, many of which the decisions your clients are making without understanding the legal significance. And so for those of us that are familiar with the various forms of title that can be taken with respect to real property, we know that at least a couple of them, joint tenancy and community property with right of survivorship, have many estate plans embedded in them, the automatic right of survivorship of a co-owner in that form of title. And that is one example where clients can take title to a particular asset and unknowingly have a bit of an estate plan embedded in their form of title to their asset that may not be exactly in support of their testamentary wishes. Many individuals don't appreciate that the state of California has a system whereby if any of its residents dies without an estate plan, that their assets at the time of their death will be distributed out to their spouse and their blood family relatives. And for those of our clients that may not choose to have the distribution of their assets go to a spouse if there's a marriage late in life, and or they have long-term committed relationships and or they have issues with their family members in which they would not want to have their assets distributed, those individuals are going to want to avoid the laws of intestate succession and affirmatively plan for a distribution in the alternative. And so what David and I and our colleagues in the estate planning field in Santa Barbara help clients with is to understand how the decisions that they are making each day, how they are going to take title to their assets, affect their unwritten estate plan, and try to avoid the laws of intestate succession and affirmatively use the tools that we have in our legal tool belt to control the nomination of their financial fiduciaries, trustees, executors, powers of attorney, and the designation of their beneficiaries, which may include people that are other than their spouse and or other than their blood family relatives. And so the legal tools that we have in our tool belt are the very common will, which is a testamentary document which can be executed and becomes operative at the time of death if the document was valid at the time of execution. And for those individuals that have over $166,250 worth of assets at the time of their death, this interesting number that has been selected by the California State Legislature, where the California State Legislature has decided over that amount of wealth, the court should be involved in the supervision of the administration of a decedent's estate. Those individuals really should have the second tool in our tool belt that we use most commonly, which is a revocable living trust. The revocable living trust is a document that requires a slightly higher level of capacity. Contractual capacity is necessary for the execution of a trust, whereas a will requires a lower level of capacity. But if our clients have a sufficient amount of wealth at $166,250 and they have contractual capacity, we often will recommend that they execute a revocable living trust. The primary focus for the execution of a revocable living trust is to avoid probate. As much as we have great respect for our colleagues that are on the judiciary, and we believe our judges do a fantastic job at adjudicating and helping determine justice, we do really encourage clients that would like to avoid the cost, the delay, the publicity, and the uncertainty of a court supervised hearing, and encourage clients to transfer their assets into a revocable living trust. The kinds of assets that are properly transferable to a revocable living trust are really any asset, real property, tangible personal property, securities, investments, any asset in which the client owns title to their asset in their name alone or jointly with another person. The kinds of assets that are not properly transferable into a revocable living trust are those that already have a contractual designated beneficiary associated with them, and more specifically, retirement assets. Retirement assets can be coordinated for distribution with a trust, through a trust, but really require the specialization of an attorney or a tax professional to make sure that any rollover benefits to a retirement plan don't get frustrated by the designation of the trust as a beneficiary. So when we help clients prepare their estate plan, we help them affirmatively plan for the nomination of their list of financial fiduciaries and their beneficiaries of choice. And through the affirmative estate plan, in addition to determining how their estate will be distributed at the time of their death, we also encourage them to plan for the possibility of incapacity prior to death. And so COVID has certainly heightened the awareness of many of our citizens that of the possibility of a temporary or permanent incapacity prior to death. And in addressing those concerns of clients that wish to plan for the possibility of incapacity, we encourage clients to prepare durable powers of attorney and advanced healthcare directives so they can nominate an agent to make financial decisions and healthcare decisions for them should they become incapacitated. And so for many of you that are helping families with real estate transactions at a time where a family member may be experiencing incapacity or death, you will be more familiar with the title holders being the successors in interest or these financial fiduciaries executing real estate documents as a power of attorney, as an executor, and as a trustee. And with respect to sales being made by trustees, we have a different set of disclosures that are permissible for sales under the real estate contract when the trustee has not been a residential occupant of the property that's being sold. And then in addition to avoiding probate and being able to control the nominations of financial fiduciaries and beneficiaries, an additional goal of estate planning is to coordinate the tax impacts of the death or incapacity of a real property owner. And those tax impacts can include property tax, which David will speak to, income tax, the step up in basis to avoid capital gains at the time of the death of a real property owner, and estate taxes. Estate taxes are those taxes that are assessed currently on those individuals who have a gross taxable estate at about $11.5 million or so. And David will speak to the kinds of additional trusts, specifically irrevocable trusts, that can be used to reduce or eliminate estate taxes as part of the more comprehensive plan. And so after David speaks to those particular issues, we will circle back and then talk about the Proposition 19 and the pay on death deed, which many of you indicated were points of curiosity and inquiry for both of you. And then for all of you, and then both of us will answer any particular questions that you have about the experiences that you've had and how estate planning intersects with escrows involving these fiduciaries, or any questions that you have regarding your own particular experiences with estate planning.
Thanks so much, Lori. And we're going to now turn it over to David. And I want to come back to all the attendees. Please don't be shy. Go ahead and put any and all of your questions in the chat function. I'll be monitoring that. And we're going to turn it over to you now, David.
Well, thank you so much. I'm David Graff of Allen & Kimball, and I'm going to first like to echo Lori's sentiments that it's very nice of you guys to have us speak to you, and we very much appreciate the opportunity, and we're happy to hear to answer questions. So if a question does come up in your mind, put it in the chat. We might not necessarily answer it right away, but I'll try to scroll through some of that as we go forward. I think that, not to kind of go a few things out of order, but it's probably a good time to throw in a couple of words about those transfer on death deeds, just because it fits in well with what Lori was just talking about how if anybody owns any property over, and I'm not even going to quote the exact number, say $160,000, and obviously anybody in this county that owns real property, unless it's heavily mortgaged, you're going to have more than $160,000. And so it's important. Most people would then have some kind of a trust to avoid having to go through the probate process, which is, again, expensive and time consuming. And so it was about 5 years ago or so, a Los Angeles assemblyman thought it would be a great idea to allow people to avoid having to go to wonderful estate planning attorneys like Lori and myself and others to have to do estate planning. And gosh, wouldn't it be easier if we could just transfer this real property with some kind of a deed, as opposed to having to go to court and go through the probate process. Similar to how a transfer on death designation works on a bank account, which we've had forever, or some kind of beneficiary designation on a life insurance policy or anything else. I will be perfectly honest, in the last 5 years since this creature has existed, I have seen none, worked on none, and don't even know that anybody has ever done one. And I don't know, Lori, have you ever seen one before? Has anybody in the audience ever seen one before? So I'll just give a laundry list of reasons why that's not the case, why that is the case, that we just don't see these things. For one thing, and I'll just run through this. They're limited to property in which there's 1 to 4 residential dwelling units. So if you have an undeveloped lot, you can't use it. If it cannot be used if the interest is currently held in joint tenancy or community property with right of survivorship, so it can't override some existing otherwise estate planning. You have to name an individual, and this is probably the biggest reason why we don't see these. You cannot name your children. You cannot name what we call as descendants or issue. You have to actually name, your son Larry or your daughter Claire. You can't actually name you can name perhaps a group of people, but you have to be specific. So if one of your kids predeceases you, your whole plan can get thrown out the window. It only works to transfer property in equal shares. So you can't say 25% to this person, 75% to that. You have to another big thing, you have to actually record the thing timely. And so it's all going to be public, meaning that if you want to change your estate plan from time to time and you don't want to tell which kid or whatever you're giving your property to, you can't do it because they're going to find out, or they can find out. Everything has to be outright. And I'm not sure if that works with a minor child exactly, but sometimes you don't want to leave property to somebody just outright where they can do whatever they want with it. And it can't be part of some kind of part gift, part sale thing. It's got to be purely donative. And there's certain other restrictions about who you can give it to. So pretty much for all those reasons, we just don't see it. So I'm not going to really spend too much more time talking about it unless somebody has a really specific question, which we can answer. So that's kind of flows in with how the estate planning works. The other thing I'll mention, and Lori brought this up very clearly, is that you often have situations where trusts continue or are formed upon somebody's death. When a trust is formed after somebody's died, or possibly somebody is making a current gift of property, it's often done to an irrevocable trust. And I think the biggest thing to know when we talk about irrevocable trusts is that they are just that, they are irrevocable, meaning they generally can't be changed. Not only can they not be changed, but property is generally not distributed from these trusts without very clear, explicit instructions, and almost always attorneys are involved. So I just think public service announcement, I guess. If you run across an irrevocable trust, before you transfer the property out of that trust or are involved in that process, you want to make sure you're working with another advisor that clearly understands whether or not that's appropriate, and whether or not the trustee or the person that's in charge of that trust is or isn't perhaps violating one of their duties in doing so. We see this a lot. The other thing to know is that, as Lori also mentioned, that there's a lot of tax reasons that people set up these trusts. And by taking something out of a trust for a particular reason and then maybe putting it back in, or transferring property in and out of these trusts, sometimes that could have extremely bad tax consequences. Sometimes ironically beneficial tax consequences, but you really need to have other advisors, I think, involved in the process. So one of the things that we like to do, and I'm sure I know Lori does this too, is make sure that everybody's on the same page. We work well with communicating with real estate agents and brokers like yourselves to make sure that everybody is understanding the transaction properly. I know there's a lot that sometimes we lawyers will learn from you in terms of how a transaction perhaps has to be structured in order to get the sale completed, those kinds of things. So that the open communication is the key.
David, just to
yeah.
make this a little interactive, because we now have some questions coming in. If it's okay with you and Lori, let me just start with Marcella, who asks, how long does it typically take to set up a revocable trust?
Lori, how long in your office?
Well, certainly the answer depends on the level of the complexity of the trust. If the trust is being prepared for tax purposes, we're going to need to work within the schedules of the tax preparer, appraisers, and other professionals, insurance companies, in order to make sure that the transaction is properly completed. But in general, if we have a client who has a time-sensitive health issue or intends to go on some risky travel or feels like they are exposed to a significant risk that they want to avoid having without an estate plan, we can usually complete a project within 10 days to 2 weeks or so.
Yeah, I think that's a fair assessment. I think the answer, like everything, is it depends. And one of the other things to keep in mind is that, generally speaking, when you create a revocable trust, it's an estate planning document. And so it's not just, how long does it take to put the words on the paper? It's actually working with the client to make sure that they understand this is what happens to your property when you die. And is that what you want to have happen? And so rarely does somebody come into our office and say, this is what I want as part of my plan. This is exactly how it's going to be structured. And that's what really comes out as the end product. Oftentimes there's a discussion about what you really want to accomplish, all of your goals, and this, that, and the other thing.
I would echo that. I would say that for clients that are prepared, decisive, and available, we can usually prepare the document faster than they can make their decisions. So I think, so I don't believe our office would be the cause for the delay. Usually our first meeting will be fairly thought-provoking, and clients will say, that's a good point. I hadn't thought about that. Let me go back to ground one and rethink my plan. And so I definitely think that David is correct. Many times the educational process will be surprisingly complex to clients who think of themselves as simple, And you realize that they're in a third marriage with 8 children between them, none of them in common, and they have property all over the United States, with some of which are in other long-term irrevocable trusts, and they have a premarital agreement that does not match what their current testamentary wishes are. And that takes a significant amount of analyzing how to proceed through the maze of existing documents and decisions and come up with the highest and best solution considering all the options.
Well, thanks to both of you for that one. I'm sure Marcella appreciated that. Now let's turn to Jean's question, and she asks, for an older revocable living trust done elsewhere, would you review it, handle the needed beneficiary updates and recommended changes, or do you generally require drawing up a new trust by your firm? And then a follow-on question to that is that work done on an hourly or contract basis, and approximately what are those fees? I don't know if we want to get into fees today. That could be a follow-up, but certainly the core of Jean's question, I think would, I'm sure she'd appreciate hearing from Lori and David.
Well, I'll just quickly mention, and Lori can follow up, that just tailing off of what Lori was just saying, oftentimes what makes a particular project more expensive is not necessarily the size of the estate. You can have a client that has $100 million between real estate and securities accounts. And if he says, I just want to leave it all to one charity, that may take very little time to put together. However, you can have somebody that doesn't have very much, obviously everything's relative, but say $1 million of wealth total. But like Lori said, the client with 5 marriages and 3 prenuptial agreements and kids from 8 marriages and all sorts of things. That's what generally makes things more complicated, and the complexity leads to cost, because we generally do charge by the hour for things, and on occasion we can do flat fees under certain circumstances, but generally it's an hourly thing. So.
Lori, anything to add? I think, Jean, we covered your follow-on question. Do you recommend a definite a dollar amount or percentage to the beneficiaries? And then I'll go on because we have a question from Liz.
Well, let me just finish up the other question, and I would just highlight that part of the plan that David and I and our colleagues try to plan for is litigation avoidance. So certainly in this world, anybody can fight about anything, anytime in court, right? We have an equal access to justice. And that does not mean that anybody who fights about anything, anytime in the court will be successful. And so really our offices and the offices of other attorneys that are preparing estate planning documents are really trying to avoid litigation. And how litigation usually gets avoided is managing expectations and clear communication and documentation. So that's really where a lot of our complexity gets managed, is preparing documents that manages the expectations of the parties and their anticipated beneficiaries, and create evidence that can be used to convince parties that litigation is not necessary or it won't be successful. And with respect to the question regarding what kinds of gifts are preferred to beneficiaries, specific bequests or percentage gifts, You know, it really depends. There are many individuals that say, I want to leave a small remembrance to a particular person. I do not want that gift, the amount of the gift, to ebb and flow with the value of my estate. I don't want it to get any bigger, and I don't want it to get any smaller. And for those individuals, specific bequests to beneficiaries are perfectly fine, as long as they also understand that if their total estate is reduced to nearly nothing because of an expensive final illness, that that specific gift may end up being the only gift that is given. So we have to educate clients about the pros and cons of either choices, but I think both are valid in varying circumstances. Absolutely.
Thanks, Lori, for that follow-on. Liz's question is to David. David, could you clarify the title issue of transfer on death deed? I know we haven't talked about that much yet. In name of the children. So additional details would be great for Liz.
I'll speak to that in just a sec. Just to follow up on what Lori just said, I just had this conversation with a client of mine recently who wanted to leave some amount of money, and he thought that a percentage of the estate would be a good idea because he wanted to make sure there was enough to go around for everybody. But the one thing that people forget about is that if you leave even a charity, say 1% or 5% of whatever your estate is, and you think that, well, that's fairly small, the one thing to keep in mind is that anybody receiving a percentage of your estate all of a sudden is perhaps going to be very interested in the values of everything in your estate, because their share depends upon it. And so if you've got, sometimes it's easier to pay somebody $1,000 or $10,000 and be done with it, because once they get their money, they can't really argue about anything. As opposed to having somebody, you know, sticking their nose into all the different business interests that the person had when they died. So you just have to think about everything. I did speak too quickly, I apologize. But when I was rattling off the reasons why the transfer on death deed, we generally don't see a lot of them. One of the reasons is because you cannot name a class of individuals. You can name, let's say you've got somebody with 2 kids, a son and a daughter. You can name the son and the daughter equal shares. And whichever, you know, if somebody dies, the son and the daughter get the property, and that works out just fine. However, you can't just name my children. And so therefore, if the daughter dies before dad or mom, whoever it is, and leaves grandchildren, those grandchildren just might be out of luck the way that the deed has to be drafted, because then everything's going to go to the son, perhaps in that situation, because there's no what we would call by right of representation or per stirpes, if you've heard that word. There's no flow through to what that daughter's share would have gone to her kids. And so it could really cause a lot of problems with your estate plan. And so that's another reason that we don't usually see these deeds. And so with that, I could start. I know it's already 12:45 and we haven't even touched Prop 19. And so I already see a Prop 19 question. So I don't want to hijack the presentation, but it might be nice to speak about that for 10 minutes. We can come back to some of these other issues.
Yeah, let's do that, David. I think it's timely to now move on. It's another hot topic for us. Thanks.
Yeah. So one of the things to keep in mind with Prop 19 is that there's actually 2 parts to it. Actually, the fact that there's 2 parts to it is actually one of the legal challenges to whether or not it was even valid. So for the purposes of this discussion, we will assume that it is good law, albeit a confusing one and an ambiguous one and perhaps a sneaky one. But the 2 big parts of Prop 19, one part of it has to do with the effect of the changes on the parent-to-child exemption from reassessment. And then the other part of it has to do with flexibility in individuals that are of a certain age to move from one house to another and retain their existing low property tax base. And so we'll tackle the first one first, which occurred first in the sense that if you're interested in planning around it, you're pretty much out of luck. The first portion had an effective date of yesterday, 2/15, which means that as of today, any future transfers that have an actual transfer effective date today or in the future, you're under the new law for parent-to-child transfers. It used to be, and many of you perhaps are familiar with this, that a parent leaving property to a child or children, and also in certain grandparent-grandchild situations, the child gets to inherit their parents' low property tax base. So you have many families that have owned property here since the 50s or 60s, and if mom or dad's property tax bill is $1,000 because they are paying on a valuation of $15,000 or something extremely low, or I'd say $100,000 or something extremely low because they've owned the property forever. Their children, at least up to till today, could inherit that $1,000 a year property tax payment, even though the home might be worth $4 million. And certain members of our community and around the state thought that wasn't exactly fair. There's a particular number of high-profile examples of this. There is a rather expensive, valuable property on the beach in Malibu that Beau Bridges left to his sons, and people thought, well, why are these Hollywood mogul types getting away with paying virtually no property taxes on these properties that they're essentially vacation homes or rentals, and that's just not fair. And so between that and encouraging people to actually transfer their real estate, a proposition was put on the ballot and it passed. And essentially, that concept of passing your low property tax base is gone, but for a very small, narrow exception, where families can pass a personal residence. And it's got to be a personal residence of the transferor, meaning the parent. It also has to be or will be the personal residence of the transferee, meaning the child. And so as long as it was mom and dad's house, and the child is actually going to move into that house, if that scenario fits, then you can capture a parent-child exclusion of that low property tax base. But even in that situation, it's narrow and it's reduced to a benefit of, at the most, essentially $10,000 a year savings. And I say that as kind of a bottom line because there's a fancy mathematical formula that will say, well, if you got a property tax base of $100,000 and the property is really worth $4 million, even though it's the kid moving into mom and dad's house, we're only going to give you a benefit on the first $1 million of increased assessment, and then so that might bring you from 100,000 to 1.1. You're still going to be paying higher taxes on the difference between that and up to the $4 million value of that property. There is also a narrow exception for family farms, and that is perhaps applicable to some parts of the county, especially if you've got avocado ranches or wine property, or even marijuana farms. And so in various parts of the county, you may see that as being applicable. In that situation, obviously the child doesn't move into the farm, and there may not even be a residence on the property. And the mechanics of how that works are still being figured out. The law was passed without very much explanation or detail. And so the Board of Equalization is going to be filling in a lot of these details as we go forward and through regulation or property tax rules. I sat in on a presentation about this recently. I'll put it in the chat so that everybody can have it, but I'm putting in a link to the Board of Equalization's website, and they've got a fairly robust explanation of Prop 19. And so I encourage you to go there. There's a whole series of question and answers. So if we don't get to something today, check out that website. Your question may be answered there. So that's the parent-child exclusion part of things. Going forward, what's going to really perhaps impact your business is you're going to see a lot of people that have owned their home for a very long period of time. How long do people need to live there to maintain it? Forever. As far as I know, that was one of the responses the Board of Equalization gave. So if you got the child moving in, they're going to say, this is my primary residence, and I want to capture that. As far as I know, the child can't leave. The second that no longer becomes their primary residence, say they start renting it out, you lose the benefit, and there might be a reassessment at that time. Again, we're still trying to figure out all the details of all of that. And it's confusing. So anyway, the other part of the law is the business about capturing your low property tax base and taking it with you. So this is different. This is not transferring it from parent to child or grandchild. This is keeping it yourself, but you just don't want to stay in the house that you've lived in forever. We've always had this concept, but now it's greatly expanded. It used to exist only within the same county. And if you wanted to move from one county to another, there was a very short list of about 10 counties that participated in this allowance of moving from, say, LA to Orange County or to Santa Barbara to Ventura. Now it's a statewide, well, I shouldn't say exactly now, but it's a statewide proposition now, where if you live in, you bought a home in Santa Monica in 1970 for $100,000. It's now worth $4 million. You can now move up the coast to Santa Barbara, buy a new $4 million home, or less than that, and your property tax bill is not going to change. The effective date for this one is a little different. It's April 1st, but that shouldn't necessarily stop you from doing certain transactions now. And I say that because some of the initial guidance that we've received on this is that in order to qualify under the new proposition where you can move from one county to another and keep your property tax base, the full part of the transaction has to be completed after April 1st. Because that's when the law takes effect. But that's the full part of the transaction, meaning both ends. So what they're saying now is that if you sell property today, let's say you sell your Santa Monica place today, and you haven't bought your new home in Montecito just yet, you can sell the property today, buy the new place after April 1st, or perhaps close after April 1st. Maybe you go under contract sooner than that. And you should still qualify under the new law. And so it's that both ends of the transaction, they're saying, have to be completed after April in order for the law to take effect. The other thing is that historically, this idea of transferring or keeping your low property tax base was meant for folks 55 and older or disabled. It's now expanded more so for people. We talked about forest fires earlier in the context of insurance. If you have your home burned down in a forest fire, this is now applicable to you, even if you're not yet 55. So it allows folks that have been harmed to take advantage of this. The other aspect of how it's new is you can do this now up to 3 times. before you could really only do it once. So now you can move from place to place to place and keep that low property tax base. So I'll
And
pause.
David,
Yeah.
we have one more question before I need to ask the two of you to wrap up so we can go to the raffle. Sharon, as you see in the chat, is asking about commercial properties. And she says that the tenants usually have triple net lease. So if their landlord dies, they're stuck with the huge increase in property tax. Also awful for family businesses, examples, restaurants, retail, and so forth. Can you just very briefly touch on that? You can see we could actually spend more than the time we have today, and we'll see if the members would like to invite you back for follow on. But for now, could you just comment on that before we go to the raffle?
Sure. And the only thing to comment on is that I agree with the sentiment that it is sad because that's absolutely right. Obviously, you cannot move into commercial property as your primary residence, which means that effectively there is no parent-child exclusion anymore for commercial industrial properties. And check your leases. Many tenants have triple net leases. However, even if you have a triple net lease, sometimes there is a provision in those leases that allows for if the property taxes do go up due to some kind of event like a death or a transfer of the property, who bears the burden of paying those higher taxes, the tenant or the landlord? And so depending on if you do commercial or anything like that, work with a real estate attorney to help negotiate those leases. Or perhaps if you got an existing lease, read it carefully to find out what it says, because you may still be able to renegotiate that before some future transfer takes place. But that's a big hit.
Yeah. Thanks, David. Lori, in terms of our wrap up, would you like to add further before we go to the raffle?
Yeah, I think just in terms of concluding our time today, I think it's fair to imagine that one of the concerns or curiosities of the attendees may be how can they limit their liability in relation to the issues that we've talked about today. And I think that David and I would probably encourage each of you, as you have clients that are acquiring property and having to decide how to take title to their property, defer that decision to their attorney or their tax professional, somebody who has more familiarity with their long history of their family, their documentation, tax base, etc. I think some realtors find themselves in awkward positions where clients expect you to give legal advice, and I would encourage you just to pass on that. Likewise, when clients are engaging in a transaction, selling real property or acquiring property in the name of the trust, really encourage them to produce a copy of the trust, verify that the power of sale is included, encourage them to notify their attorney or tax professional in advance of the transaction. Sometimes clients actually who are as trustees may deny the fact that they have any knowledge about issues that should be disclosed in a sale, and may want to stand behind the limited disclosures of a trustee, but you may want to press further and make sure that in fact they haven't also been an occupant or a resident in the property. And certainly when there are sales being engaged in or entered into as a part of a post-death administration, be sure to ask whether or not the death occurred inside the residence because of the mandatory reporting requirements. Sometimes clients won't tell you that. and you want to make sure that you're managing your own risk of disclosure, and lead by example. Encourage your clients to have an estate plan by having the experience yourself. Make sure that you update your estate plans. Encourage your clients to update their estate plans every time they sell real property, every time they acquire real property, especially if they're from out of state and they're acquiring California property, or people are acquiring California property and they're moving out of state. We really, estate plans for individuals that have a residence outside of California or in California with non-California real property also require a lot of complexity. So get your own estate plans in place, and if you already have them, review them. Make sure you're doing that at least annually.
Great. Well, I want to give a big Association of Realtors thank you to Lori and David for being our co-panelists today. And without further ado, let's go to our raffle from Kelly Weiser of the Weiser Agency. And I think, Casey, are you going to facilitate the raffle for those who are still present? This is the Las Vegas portion of our show, just in case everybody wasn't aware of what they were going to be experiencing today.
That's great.
Devin Wong. Where's Devin Wong? Devin Wong, come forward. Okay, very good. We see, I think he may be on audio only. Great. So we have a winner, and we'll turn it back over to Casey and Kelly to hand off that. And that takes us just a couple of minutes past our forum close time. Thanks so much again to